Keep cutting. He can complain when he gets back.
That was the order my HOA president gave while a chainsaw crew destroyed my 50-year-old apple orchard. I was 600 miles away when my security camera sent the first motion alert. On the live feed, I watched workers rip down my private property sign, pull a metal survey marker from the ground, and drop tree after tree into the dirt. Those weren't decorative trees. My grandfather had grafted them by hand. They still produced the apples that supported my family business. The crew foreman warned Vanessa Crowley that they might be standing outside HOA property. She looked toward the road, waited until the sheriff's deputy had driven away, and told them to finish the job. By the time I returned, 21 heritage apple trees had been reduced to fresh stumps. Vanessa believed she had solved her access problem before I could stop her. But she had overlooked one thing. The camera had recorded every word. And under the law that applied to those trees, that recording changed everything. My name is Daniel Mercer, and my family owned that orchard long before Ridgeview Estates existed. Our farmhouse sat on 12 acres of agricultural land beside the development. We shared a boundary with Ridgeview, but my property had never been part of its HOA. I paid no dues. I had signed no covenants. Their bylaws gave them no authority over my home, my barn, my land, or my orchard. Vanessa Crowley never accepted that. She had been president of the Ridgeview Estates HOA for almost 6 years. She carried a clipboard everywhere, spoke about property values as though she had invented them, and treated every person near the development as if they worked for her. To Vanessa, my weathered barn, muddy work truck, and rows of fruit trees were stains beside Ridgeview's stone entrance and identical luxury homes. She once called my property the unfinished edge of the community, as though my family's land had spent generations waiting for her permission to exist. The orchard was the part she hated most. 21 heritage apple trees ran along the boundary closest to Ridgeview's clubhouse. My grandfather had grafted the first trees by hand more than 50 years earlier. My father expanded the row, improved the irrigation, and taught me how to prune each variety differently. Years later, my wife Sarah turned the fruit into a small but reliable commercial operation. She found restaurant buyers. She negotiated with a local cider mill. She tracked harvest weights and seasonal orders. She even built a customer list for grafting wood from several rare varieties that local growers could no longer purchase commercially. Sarah had been gone for 4 years. But her handwriting still filled every harvest ledger in my office. 2 weeks before I left town to visit my daughter, Vanessa appeared at my gate carrying a folder marked Pedestrian Improvement Project. She wanted a 12-foot strip through the orchard. The proposed walkway would connect Ridgeview's clubhouse to a scenic overlook near the newest section of the development. Vanessa described it as a benefit for the entire community. She didn't offer to purchase the land. She didn't ask to negotiate an easement. She called it a community contribution. I told her the answer was no. The orchard was productive agricultural land, and the proposed path would run directly through the oldest trees. Vanessa stared past me at the branches. "You're holding up progress for a few old apples," she said. "They're not yours to take," I replied. She closed the folder slowly. Then she smiled. "The board has other ways to solve access problems." She walked back toward her white SUV. Just before opening the door, she turned around and looked at the orchard one more time. At the time, I thought it was another empty HOA threat. 14 days later, I was watching those trees fall through a 6-inch phone screen. I called Vanessa first. She answered over the roar of chainsaws. "Stop the crew," I said. "You're cutting trees on private property." Her voice was perfectly calm. "The board approved an emergency clearing," she replied. "Those trees obstruct pedestrian access and create a safety concern. There is no pedestrian access through my orchard. There will be." Then she hung up. I called the county sheriff's office and reported that someone was destroying my property. A deputy reached the orchard 20 minutes later while I stayed connected through the camera feed. Vanessa met him at the boundary wearing an orange safety vest and holding a map covered in HOA logos. She told him the orchard sat inside a common use corridor. It didn't. The document she showed him wasn't a deed. It wasn't a certified survey. It wasn't a county plat. It was a concept drawing created for the walkway project. But from 600 miles away, I couldn't place the real property records in the deputy's hands. The deputy ordered the crew to pause until ownership could be confirmed. For a moment, the chainsaws stopped. Then I watched Vanessa lead the foreman toward one of the old metal survey markers along the tree line. He bent down, examined it, and shook his head. "That marker puts us outside your parcel," he said. "We shouldn't touch anything else." Vanessa glanced toward the road. The deputy's vehicle was disappearing beyond the trees. Then she pointed toward the remaining orchard. "Finish the job." The chainsaws started again. I recorded everything as the trees my grandfather had planted collapsed one after another. Limbs shattered against the ground. Unripe apples rolled through the sawdust. 50 years of growth disappeared in less than an hour. When I returned the following morning, the orchard was silent. 21 trees had been reduced to stumps. My private property sign lay face down beneath a pile of branches. Lengths of irrigation pipe had been crushed beneath the equipment. Fresh tire tracks ran from Ridgeview's property onto mine. But the worst detail was beside the final stump. The survey marker the foreman had examined was no longer in the ground. I found it 30 feet away, buried beneath wet leaves in the drainage ditch. Someone hadn't merely ignored the property line. Someone had tried to erase it. Vanessa arrived before I finished walking through the damage. She stepped around the fallen branches in polished boots and handed me an envelope. Inside was a check for $5,000. "A landscaping allowance," she said. "More than fair for 21 aging trees." I looked past her at the fresh stumps. My grandfather grafted those trees 50 years ago. Vanessa shrugged. "They were old, Daniel. Ridgeview is improving this area." That was the moment I understood she genuinely believed she had destroyed nothing more valuable than unwanted landscaping. Those trees produced nearly 9,000 pounds of apples during a good season. Local restaurants bought them for pies, preserves, and seasonal menus. A nearby cider mill reserved part of every harvest months in advance. Families who had purchased apples from my father still came to our farm every autumn, but the rarest income came from the branches. Several trees carried heritage varieties that local growers could no longer obtain through ordinary nurseries. Every winter, I sold carefully selected grafting wood to orchards across 3 states. Sarah had documented everything: orders, harvest weights, restaurant contracts, cider invoices, tax returns, shipping records, handwritten notes showing which trees produced the strongest grafts. That evening, I opened the cabinet where she had stored 30 years of business records. Her handwriting covered every page. Vanessa had offered me $5,000 because she saw 21 pieces of wood. The ledgers showed something else entirely. They showed a functioning commercial orchard with decades of proven income. I called an attorney the next morning. Her name was Laura Bennett. She specialized in property and agricultural disputes. She studied the photographs, the missing survey marker, the concept map, and the recording of Vanessa ordering the crew to continue. Then she opened Sarah's final harvest ledger. "How much did this orchard earn last year?" she asked. I gave her the number. She stopped turning the pages. "Daniel, this isn't a landscaping claim." She looked back at the camera footage. "This may be a commercial destruction case." Laura's first request was simple. "Ask the HOA to show you exactly what gave them the right to enter your land." I sent Vanessa a formal demand for every deed, easement, survey, permit, and board resolution connected to the walkway. 3 days later, Ridgeview's property manager delivered a thick envelope to my door. It looked impressive. There was a glossy walkway proposal, a landscaping diagram, meeting minutes, contractor documents, and a page titled Emergency Pedestrian Access Authorization. But there was no deed, no certified survey, no easement signed by me or anyone in my family. The only map showing the orchard inside HOA property was a colored concept drawing created by the same company hired to build the walkway. Vanessa had taken a design sketch and treated it like a legal boundary. Then the HOA sent me a violation notice. According to the letter, I had 7 days to remove the stumps, clear the remaining debris, and allow their contractor to finish the path. They also demanded that I reimburse Ridgeview for project delays. Vanessa had cut down my trees, entered my property without permission, and now wanted to fine me for the mess she had created. At the bottom of the notice, one sentence appeared in bold letters. Failure to comply may result in daily fines and a lien against the property. There was only one problem. The letter identified my orchard as part of HOA Parcel C. I opened the county deed that had been in my family's record since 1972. Parcel C ended 43 feet before the first apple tree. Laura read the violation notice twice. Then she smiled. "Don't respond to Vanessa yet," she said. "Let a licensed surveyor put this in writing." 2 mornings later, a survey crew arrived with metal detectors, tripods, and copies of the original county plat. By noon, they had located 3 buried boundary pins. The line they marked didn't merely prove the trees had been mine. It showed that the unfinished walkway extended more than 20 feet into my property. The certified survey arrived the following afternoon. Every apple tree had stood completely inside my boundary, not close to it, not partially across it. The nearest stump was 18 feet from Ridgeview's property line. The farthest section of the unfinished walkway extended 26 feet onto my land. There was no pedestrian easement anywhere in the county records. Laura placed the certified survey beside Vanessa's concept drawing. On the HOA map, the boundary curved conveniently around the orchard. On the county plat, it ran straight past it. Someone had moved the line on paper to make the walkway appear legal. But the false map could still be blamed on carelessness. Vanessa could claim she trusted the wrong document or misunderstood the location of the boundary. The camera footage removed that excuse. I downloaded the files directly from the recorder, preserved the original timestamps, and gave Laura an unedited copy. We watched the foreman stop beside the metal survey marker. He pointed toward the trees and spoke clearly. "Those markers put us outside the HOA parcel. We need to verify this before we continue." Vanessa glanced toward the road to make sure the deputy was gone. Then she answered, "Keep cutting. He can complain when he gets back." Laura replayed that sentence 3 times. "That's notice," she said. Vanessa had been warned before most of the orchard was destroyed. She understood there was a serious ownership dispute. Instead of stopping, she ordered the crew to finish before I could return. That changed the case. It was no longer only about where the property line stood. It was about what Vanessa knew and what she deliberately chose to do after learning it. Laura closed her laptop. "We need a certified arborist and an agricultural appraiser," she said. "And don't tell the HOA what we have yet." Before I could ask why, she opened the walkway proposal again and pointed to a small logo printed in the corner. It belonged to Bellwether Development, the company selling Ridgeview's newest homes. The HOA hadn't destroyed my orchard merely to build a walking path. Someone expected to make money from it. The walkway appeared in every advertisement for Bellwether's final row of luxury homes. One brochure promised buyers private pedestrian access from the new residences to the clubhouse and scenic overlook. The problem was obvious. That access crossed my orchard. Several houses had already been listed at premium prices because of the promised walkway. Vanessa hadn't described it as a future possibility. She had marketed it as a guaranteed amenity. Then Laura examined the construction contract. The HOA had awarded the project to Crowley Outdoor Design. Vanessa's brother-in-law owned the company. Ridgeview residents were paying for the walkway through a special assessment. Bellwether Development was using it to increase home prices. Vanessa's relative had received the construction contract. My trees had been standing between all three of them and their money. A former board secretary agreed to meet us privately. Her name was Helen Porter. She brought copies of emails from the month before the cutting. In one message, Helen had warned Vanessa that the county plat placed the orchard outside Ridgeview's property. Vanessa replied that I would never surrender the land voluntarily. Then she wrote something even more revealing. Once the path is established, removing it will become politically impossible. She had never believed the land belonged to Ridgeview. She believed that if she built quickly enough, residents and developers would pressure me into accepting it. Helen had resigned after Vanessa removed her objections from the official meeting minutes. By then, our evidence file contained my deed, the certified survey, the camera recording, the altered concept map, the contractor's work order, the developer's brochure, and Vanessa's own emails. But Laura said none of those documents answered the question that would determine the size of the case. What were 21 mature commercial apple trees actually worth? A week later, 2 specialists arrived at the orchard. One was a certified arborist. The other valued agricultural businesses. They spent 6 hours measuring the stumps, examining the remaining roots, studying old photographs, reviewing invoices, and calculating how many years it would take replacement trees to produce the same income. The arborist used the diameter of each stump, pruning records, harvest reports, and photographs to estimate the condition of every tree before it was cut. The agricultural appraiser didn't ask what 21 young apple trees would cost at a nursery. He asked how long it would take new trees to produce the same fruit, the same grafting wood, and the same reliable revenue. The answer was years. Some of the heritage varieties could be preserved from grafts stored at a regional nursery. Others might never be replaced exactly. Then he opened Sarah's ledgers. They showed decades of steady production, recurring customers, seasonal contracts, and documented tax income. The orchard wasn't a hobby. It was an established commercial asset. When the specialists finished, the appraiser closed his folder and placed his estimate on the hood of my truck. "Mr. Mercer, the HOA didn't destroy 21 trees," he said. "They destroyed a functioning production system." Their preliminary valuation came to nearly $100,000. When Vanessa's attorney received the report, he called the number absurd. He argued that Ridgeview should pay only the retail cost of 21 replacement saplings. Laura expected that response. She placed the relevant state statute beside the camera transcript. Under the law that applied to our case, knowingly cutting trees on another person's property could expose the responsible party to multiplied damages. The difference between an honest mistake and deliberate destruction mattered. That was why one recorded sentence carried so much weight. "Keep cutting. He can complain when he gets back." Vanessa had been warned about the boundary. She had waited until the deputy left. She had ordered the crew to continue. And the walkway had been advertised before the HOA possessed any legal right to build it. Laura sent Ridgeview a final demand to settle, remove the unfinished construction, withdraw every violation against my property, and compensate me for the destroyed orchard. Vanessa rejected it within an hour. Then she did something even her own attorney hadn't approved. She scheduled an emergency HOA meeting and told the entire neighborhood that I was attempting to extort them over a few dying trees. She expected the residents to pressure me into backing down. Instead, she gave us a room full of witnesses. 2 days before the meeting, another certified letter arrived. Vanessa was now fining me $500 a day for obstructing an approved community improvement. She also threatened to place a lien on my property if I refused to remove the stumps and reopen the construction site. The HOA had no authority over my land, but Vanessa kept printing notices as though enough paper could change the deed. I didn't argue with her. I added every letter to the evidence file. Then the tree crew's foreman called Laura. Vanessa had blamed his company for crossing the boundary, and he was no longer willing to protect her. He turned over the original work order, his text messages, and a photograph taken before the cutting began. In one message, he had written that a survey marker had been found, the boundary might be disputed, and work should stop. Vanessa had replied with 4 words: "Proceed as scheduled." Then she added that the board accepted responsibility. The foreman also confirmed that she ordered the crew back to work after the deputy left. By the morning of the emergency meeting, even Vanessa's attorney was urging her to cancel it. She refused. Instead, she emailed every Ridgeview resident and accused me of trying to bankrupt the neighborhood over 21 unhealthy trees. More than 80 homeowners packed the clubhouse that evening. Vanessa stood behind the podium with my violation notices projected onto the screen. She believed the crowd had come to help her force me off my own land. Laura and I entered carrying 1 laptop and a single black evidence binder. Vanessa smiled when she saw us. That smile lasted exactly 9 minutes. She opened the meeting by displaying photographs of the unfinished walkway. Then she described me as an angry neighbor trying to hold Ridgeview hostage. "The HOA acted in good faith," she told the room. "Mr. Mercer is demanding an outrageous payment for trees that were already old, diseased, and standing inside a community access corridor." Several residents turned toward me. Vanessa lifted one of her violation notices. "If he continues obstructing this project, every homeowner may be forced to pay." Laura leaned toward me. "Let her finish." For the next 8 minutes, Vanessa blamed the contractor, the county, and me. She insisted the board had relied on official property records. Then she invited us to respond. I walked to the front carrying the black binder. The first document I placed beneath the projector was my county deed. The second was the certified survey. A red line showed Ridgeview's boundary, ending 43 feet before the orchard. Another line showed the walkway extending 26 feet onto my land. The room went quiet. Vanessa pointed at the screen. That survey was commissioned after the work began. Laura stood. The original county plat shows the same boundary. She displayed the archived map beside Vanessa's concept drawing. On the HOA version, the property line curved around the trees. On the county record, it ran straight past them. Next came the agricultural registration, Sarah's harvest records, restaurant contracts, tax documents, and the preliminary appraisal. Vanessa laughed when the valuation appeared. "No reasonable person believes those trees were worth that." "That isn't the most important number tonight," Laura replied. She projected the developer's brochure advertising private walkway access. Then she displayed Vanessa's email admitting that I would never surrender the land voluntarily. Residents began whispering. Helen Porter, the former board secretary, stood and confirmed that she had warned Vanessa about the boundary before construction began. Then the tree foreman rose from the back row. "I warned her at the site too," he said. Vanessa's face changed. Laura opened the final file. The clubhouse speakers crackled as the security video began. On screen, the foreman pointed to the metal survey marker. "Those stakes put us outside your parcel. We need to stop." Vanessa looked toward the road where the deputy had disappeared. Then her recorded voice filled the clubhouse. "Keep cutting. He can complain when he gets back." Nobody moved. Laura paused the video on Vanessa's face. "That statement matters," she said, "because state law treats a boundary mistake very differently from knowingly destroying trees on another person's land." The HOA treasurer slowly removed his board badge and placed it on the table. A homeowner near the front asked who had approved the contract with Vanessa's brother-in-law. Another demanded to know why residents had been charged a special assessment for a walkway the HOA had no right to build. Vanessa reached for the microphone. Her own attorney pulled it away. The emergency meeting ended without a vote. The following morning, we filed the lawsuit. Ridgeview's insurance company tried to settle before the case reached court. They offered to replace the trees with 21 young saplings and pay 3 years of estimated harvest income. I refused. A sapling wasn't a 50-year-old commercial tree, and 3 years wouldn't restore an orchard that had taken generations to build. At trial, Vanessa's attorney called the cutting an unfortunate boundary mistake. He said she relied on the HOA's landscaping map and believed the walkway crossed common property. Laura placed the certified survey in front of the judge. Then she displayed the archived county plat, the email warning Vanessa about the boundary, and the contractor's text recommending that work stop. Finally, she played the camera recording. The foreman's warning filled the courtroom. "Those markers put us outside your parcel." Then came Vanessa's answer. "Keep cutting. He can complain when he gets back." Her attorney argued that it was only an impatient remark. The judge disagreed. Vanessa had received warnings before construction began. She had been warned again at the orchard. She waited until the deputy left. Then she ordered the crew to continue. That wasn't confusion. That was a decision. The agricultural appraiser explained that the trees were part of a functioning production system. Their value included proven harvest income, rare grafting stock, customer contracts, restoration costs, and the years required for replacement trees to become commercially productive. The HOA's expert tried to value them as ordinary nursery trees. Under cross-examination, he admitted he had never reviewed Sarah's ledgers, our tax records, or the orchard's sales contracts. The judge calculated the qualifying loss at $100,000. Then she turned to the state statute. Because the destruction continued after Vanessa received clear notice that the trees might belong to someone else, the court found her conduct knowing and willful. That finding activated the statute's multiplied damages provision. The courtroom became completely silent. The judge looked directly at Vanessa. "You believed completing the project quickly would make the property dispute irrelevant," she said. "Instead, your decision made the distinction between a mistake and intentional destruction unmistakably clear." She entered judgment against the HOA. $300,000. Every violation notice against my property was declared invalid. Ridgeview was permanently barred from completing the walkway. The HOA was ordered to remove every piece of construction placed across my boundary. Vanessa stared at the judgment without moving. 3 months earlier, she had offered me $5,000 for a few aging trees. Now the number printed beside her name was 60 times larger. Outside the courthouse, reporters asked whether I felt vindicated. I looked at the photograph of the old orchard inside Sarah's final ledger. "The money proves they were wrong," I said, "but it doesn't put the trees back." That part required something no judge could order. Vanessa resigned as HOA president 3 days after the judgment. 4 other board members followed her before Ridgeview residents could vote to remove them. The new board canceled the walkway, opened the HOA's financial records, and ordered an independent audit of every contract connected to Vanessa's family. The unfinished section on my property was torn out. I watched the concrete disappear from the same ground where my grandfather's trees had once stood. Then I installed new boundary markers, a fence, and a sign large enough to be read from the clubhouse. Private commercial orchard. No HOA access. but I didn't want 21 empty stumps to become the final image of Sarah's orchard. Years earlier, she had persuaded me to send grafting wood from our rarest trees to a regional heritage nursery. At the time, I thought she was being overly cautious. After the trial, that nursery called. They still had living stock from 14 of the original trees. That spring, volunteers from the town helped me plant a new orchard along the same row. Children carried buckets of water. Retired farmers taught younger families how to protect the grafts. Even several Ridgeview residents crossed the boundary to help. The new trees were small. They would need years before they produced a full harvest. But they carried the same living wood my grandfather had grafted half a century earlier. I used part of the judgment to establish a local heritage orchard program in Sarah's name. It provided grafting stock, boundary surveys, and legal assistance to small landowners whose farms were being surrounded by new developments. Ridgeview's new board also adopted a rule requiring a certified deed review and survey before any future project could approach private land. Vanessa had believed an HOA title, a clipboard, and a construction crew gave her the power to erase 50 years of work in a single afternoon. She was wrong. A property line doesn't disappear because someone removes the marker. A family business doesn't become worthless because someone calls it landscaping. And ownership doesn't belong to the loudest person in the room. It belongs to the person whose name is on the deed and who has the evidence to prove it. So tell me this. What would you have done if you had watched someone destroy your family's legacy through a security camera? And how much would 21 50-year-old apple trees be worth to you? Subscribe for more stories where patient homeowners, real documents, and the law expose people who mistake authority for ownership.